The Jolly case, if you're a lender, is completely misnamed. There's nothing jolly about it. It is a very difficult read for anybody affiliated with a lender in California, because it involves a situation that under prior case law would have probably never made it past a demur or past a motion for summary judgment. But in the case of Jolly, it involved a borrower who was a borrower under a construction loan, who was originally, his loan was with Washington Mutual, WAMU. Later on, Chase acquired that loan after WAMU was taken into receivership by the FDIC. Chase became the successor lender, and ordinarily that is a transition that provides a lot of protections for the lender. But in the case of Jolly, for a variety of reasons, some of them procedural, some of them substantive, the court really held Chase to blame for some of the conduct that occurred before Chase acquired that loan. The claims involve things like negligence, fraudulent misrepresentation, reformation, and essentially what the borrower was saying was, boy, when I was with WAMU, they were promising me I was going to get this great restructure on my loan, and I was going to be able to get additional funds and a fully amortized loan to finish this project and move on, and I was paying. And then when the transition went over to Chase, Chase said, well, we'll consider that modification you were looking for from WAMU, but at the same time, after he stops paying, they say we're also working on foreclosure. But where the court was most put off was representations from the second lender, Chase, where they said, boy, that modification looks good, or it's likely that there will be a modification. And when those statements were made, ordinarily in past case law, statements of opinion about future events are not actionable fraudulent misrepresentations. But in this case, the court said, well, it implied a factual basis. It implied that there was actually a significant chance of a modification coming through, and that was a misrepresentation. In addition to that, for me, the most disturbing part of the opinion is the focus on is the negligence discussion. Typically, under past California law, lenders who are acting as, for example, construction lenders who are making ongoing construction disbursements, they are not subject to a negligence duty of care to their borrower. They're acting in an ordinary role as a lender, a conventional lender role. But the Jolly case said, oh, no. Despite other cases that have found that no duty of care exists there, that's an ongoing relationship that warrants the imposition of a duty of care. And if you think about it, there are a lot of cases where the borrower says, I was moving along fine on my construction, and the lender stopped paying this draw or stopped paying that draw, or took too long to fund my draws, and they're now going to use that as a method to blame the lenders for the failure of their projects. And if you can't get out on summary judgment, you are now a lender before a jury on a negligence claim, which obviously imposes quite a bit of risk.
So all of those situations in 2009, 2008, 2009, and 2010 from all of those developers who all of a sudden couldn't finish their development because they weren't meeting certain criteria to get their money on their construction loans.
Including paying sometimes, including paying interest.
Oh my goodness.
And when that happened, the typical course of this would be the lender files an enforcement action for a default under the loan, and there's a counterclaim for lender liability, something along the lines of negligence, and they will say, of course I couldn't pay because you were slow on my disbursements, and that caused my subs to walk off the job, and the project got delayed, and I had to change contractors, and they blame the lender for that activity.
Now, this is limited to construction loans. Can the logic of these cases be extended to, first deeds, someone sitting in a first position on property other than a construction loan?
Well, I actually don't believe it's limited to construction loans, even though that was the context in which the Jolly case came up. In other words, the concept here is really that the lender has an ongoing duty, even if they're the successor lender, to know the history of the credit.
Did you see my eyes get very wide as he said that?
And that's a concept that troubles lenders very much. They often get a very thin file from their predecessor core loan documents. They don't get all the emails that went back and forth between the borrower or the guarantors during the time that the loan was in its earlier phase. So that a lender walks into a lot of unknowns, and what Jolly is saying is you don't investigate those unknowns at your own peril.